Hey, okay. I had to refresh. It took me a while. Looks like we're good now. Boy, that sucker, it's that circle of whatever that never would get me over the hump, but now we're live. All right. So good to be here, everybody. Coming at you from a different venue than I have for the last 8 days, 9 days. I'm here in my office. I think you can actually see my bar certificate there in the background hanging up on the wall, signed by our, at the time, Louisiana Supreme Court judges in the conference room here. I think the lighting's pretty good. Hope the audio is okay. Good to have you. All right, big topic, all about the home, protecting the value of the home. For many people, it's their largest financial asset. Just all the usual stuff. Ron, you nailed it again. A sports joke, even better than a corny dad joke, a corny dad sports joke, and I'm a sports nut. Actually, I laughed when I read your joke. So we got some questions from Johnny. If you haven't been on these before, I love the live chat. I love it when y'all are commenting, asking. Let's see, and I see several thanks for the videos. Been watching videos for a while since your mother-in-law has moved into your home. All right, very good. Glad you're taking care of your mother-in-law. Better there than hopefully she stays out of a facility where the viruses seem to grow. All right, one question I have in regards to an irrevocable trust. What do you do with the recurring monthly income from Social Security pensions? All right, so and then let me ask your next question to see if that provides some context. Do you auto transfer those funds into the trust checking account and write checks as a distribution that pays the grantor's bills, presuming the trustee and beneficiary are in agreement? All right. So whenever I read these questions, I kind of got to guess at what the circumstances are. So I'm going to go back to the middle question. In regards to an irrevocable trust, what do you do with the recurring monthly income from Social Security, pensions, et cetera? All right, so a lot of people who have transferred assets out of their name in an attempt to get the countable resources that they own, as low as possible, many, if not all of those people still have monthly income that they get, and two common sources of income is Social Security and pension. And so let's say someone gets $2,000 of monthly income. Could be $600, could be $3,000. Let's say $2,000 for now. What do you do with it? Well, those monthly income payments, they're not a resource or an asset that would make someone ineligible for Medicaid because they have too many assets, but it is income, and Medicaid looks at income as well. But essentially, we have no choice on what to do with that. Those must be payable to that individual. They are payable to that individual. They must go directly into that individual's checking account. And then usually what happens is the individual just spends that money, because if they transfer that money, out of their name, you could be triggering another, 5-year penalty period as to that money. Now, if you had transferred other assets, 2 years ago, 6 years ago, that the 5-year, the new 5-year thing isn't going to address the old transfers. But to the extent you, like a mother-in-law has income and she doesn't spend it because she lives with her daughter and her daughter's husband, by the way, Johnny. Sometimes people accumulate, money in their accounts because they just don't spend it. So it's an issue that we have to deal with. Most people spend it, but I can see where you may have a circumstance where it's not spent. And by the way, if one goes into a nursing home and those assets are protected and they're still getting income, they're going to, even if they qualify for Medicaid, they're going to have to assign that income to the nursing home, and then Medicaid will pick up the balance of the monthly Medicaid expense. They'll get to keep maybe $38 as a personal needs allowance. They'll get to keep enough of their income to pay for their health insurance premium. So sometimes, in answer to your question, sometimes it's spent. Sometimes if it accumulates enough, money gets transferred out of the individual's checking account, realizing there'd be a penalty period for that. And we'll get into the specifics of those penalty periods in another video. And I've done other videos on penalties for transfers of resources. Okay, good questions there right off the bat, and I'm about to get into, here's my outline for today, here's my supporting documentation for today, all about the home. We're about to get into that in a minute. Hey, Paul from William, can we reinvest dividends automatically in our revocable living trust? Sure you can. Revocable living trust owns stock. That stock, titled in the name of something like William as trustee of the William Trust, and certainly can reinvest those dividends, which means all the dividends are just used to purchase more stock. And, certainly no issue with that in any kind of revocable living trust issue. So all good there. Okay. The issue today. A lot of people, this is the whole, I don't want to go to a nursing home. I don't like nursing homes, but I know nursing homes are all very, very crowded and they keep building more. One day I may have to go to a nursing home. I accept the fact that I might have to, even though I don't really want to, don't want to be a burden on my kids. Can't afford to have people around the clock in my home. That costs, $12,000 a month or more. So one day I may need the care that a skilled nursing home provides. And if I do, I own a home. I'd like my home that I spent 30 years paying for to wind up, going to my children. If I could leave that to them, that would be great. I'd prefer to leave it to them than to leave it to the government or to the state or to Medicaid or whatever. What can I do to protect the value of my home? That's what this is all about today. All right. Most, I don't know if most is the right word. Many people are aware that the home is a countable asset, countable resource for purposes of qualifying for long-term care Medicaid when you go into a nursing home. But many people are not aware of the potential Medicaid estate recovery rights upon the death of a Medicaid recipient who owned a home. And many people aren't aware that there are penalties that can make you ineligible for Medicaid qualification if you do some kind of transfer of your home prior to applying for Medicaid. And so this is all the rules and what do people do to protect what they have. I will ask you as we get into it, I basically try to sell three things on these YouTube live presentations that I've done every day for the last 10 days, and I've got 10 more coming up. I sell three things. One, I try to sell you to hit the like button. So you got a gray like button. The cool thing to do is to turn it to blue. That makes my like numbers go up, and that tells YouTube to show my videos to more people. So if you could hit the like button, that'd be great. The second thing I try to sell you on is to subscribe to my channel. I'm trying to build as much growth as I can with my channel. So there's probably somewhere around your screen, there's a red subscribe button. Hit the subscribe button. All that does is when you pull up the YouTube website, it's going to give you some suggested videos to watch. YouTube is more likely to suggest videos from channels that you have subscribed to. All of those two things that I have just described, they don't cost anything and they help me out. So whatever. Number three thing I try to sell, it is kind of selling my professional services. If you live in Louisiana, have a Louisiana issue, you can go to my website, rabelaestateplanning.com. And if you want to chat with me, there's a place where you can click, go straight to my calendar, schedule a 15-minute call, doesn't cost anything. And then perhaps we can just simply start a discussion about your needs and how they might need to be addressed and what's the easiest way to accomplish what you're trying to accomplish. Enough selling on me. Let's get down to the real nitty-gritty. Okay, I like to give you the rules, and then I like to give you the practical strategies that people use to use the rules in their right way. All right, again, most people are familiar that if a single person goes into a nursing home and they have more than $2,000 of countable resources, typical countable resources are things like money in the bank, your checking account, your savings account, your CDs, other investments that you have. In my state, retirement accounts are included. Real estate that's not your home is a countable resource. So if you have more than $2,000 of that stuff, you're just not going to be eligible for Medicaid. When you go into a nursing home, you'll be denied coverage and you'll just have to pay for your own care until you spend those resources that you have down to the less than $2,000 limit. Most people are aware of that. Many people are also aware that that exempt assets exist. So we talked just a moment ago about the countable resources, and then we talk about assets that are called exempt that don't count toward the $2,000 figure. The two most common types of exempt assets are your home and your vehicle. So, and the home typically has significantly more value than the vehicle. And, vehicles deteriorate in value. And usually by the time somebody goes into a nursing home, they've stopped driving months or years before they often sold or disposed of the vehicle. So the vehicle just doesn't seem to be as big an issue as the home. The home, typical vehicle, especially a used vehicle by someone going into the nursing home, might be worth $10,000. A home that someone has when they go into a nursing home, it might be worth $200,000, $300,000, $400,000. So that's a lot of value that they'd like to pass along to their family. What prevents them from passing that value in that home along to the family is what's called Medicaid's estate recovery rights. Many people have not heard of Medicaid's estate recovery rights. What all that means, let's say a person has a home and they have $50,000 in the bank. They take a fall, they break their hip, they got to go into the nursing home, and they realize initially they're not eligible for Medicaid. And what keeps them from being eligible for Medicaid is they have $50,000 in the bank. That's more than the $2,000 of countable resources that they're permitted to have. So maybe they spend 6, 8, 10, 12 months, whatever, spending down that $50,000 until they have less than $2,000 remaining. Then they apply for Medicaid. Medicaid does all of its application process, realizes that the person doesn't have more than $2,000 in countable resources. Yes, they have a home, and that home might be worth $300,000, but that's an exempt asset. And there had been no uncompensated transfers, had been no transfers of assets out of that person's name in the previous 5 years. They're eligible for Medicaid. And when they apply for Medicaid, Medicaid informs the applicant, Medicaid informs the family, whoever's going through that application process on behalf of the applicant. In part, some of the might be big print, might be small print, might be some of the conversations that they have, but there's a disclosure that, hey, we realize you have a home, and our state Medicaid laws require us to pursue Medicaid reimbursement after you die from your estate. And since your home is in your estate, when you die, your estate is going to have to sell your home and give that money to Medicaid to the extent Medicaid spent that amount of money on your care. So everybody just says, okay, let's just make sure we get Medicaid for now. And so that person goes on Medicaid. They stay on Medicaid for 2 years. They pass away. Family gets a bill that says, look, for the last 2 years, your mother, I'm sorry she died, but your mother spent $186,000 of Medicaid funds. Medicaid has estate recovery rights on your mother's home, your mother's estate. Please send us a check for $186,000. So then the family's got to sell the home, send Medicaid $186,000 to satisfy the Medicaid lien. So that's what we're talking about trying to avoid today. All right. And then the other potential problem is some parents who are trying to qualify for Medicaid in the future, or just trying to either avoid probate or just simplify things for their kids. Some parents say, well, let's just go ahead and put the house in the kids' names now. And they do that. A year later, one or both of them have to go into a nursing home because they made a transfer within the previous 5 years of applying for Medicaid. They don't qualify for Medicaid, even though it was an exempt asset that was transferred. Still, these penalty periods apply, so that's a problem there. All right, so there's several legal. I'm fixing to go through some rules with you, things that you can do, and as long as you just know the rules and follow the rules, you may be saving your family hundreds of thousands of dollars. All right. First thing I want to do is I want to talk about what's the definition of a home for purposes of Medicaid? So here in my state, Louisiana, every state has their own Medicaid eligibility manual. If you're outside of Louisiana, don't quote me on what our Louisiana manual says. You'll have to find yourself, inquire to someone who understands. I know in many states, a lot of the rules are the same because Medicaid's a federal program, but they allow each state to administer its own program. But let's talk about what the definition of the home is. And I'm going to give you two different definitions because home is defined in two different places in our Medicaid manual, two different ways. So in one place, the home property is defined as the property in which he or she has an ownership interest and that serves as his or her principal place of residence. Easy enough. Home property includes the house or lot, which is the usual residence. So makes sense there. Home's the house, the lot. Here's where the definition gets a little expansive. The home property includes all contiguous property. That's pretty good. So a lot of people own a home and then they'll own the lot next door. And that's contiguous property to the home. So contiguous property is also considered home property and any other buildings on the home property. So a lot of people have the farm, the barn, the shed, whatever, so under this, any other buildings on the home property is included in the definition of home property is a good thing. And then they talk about what contiguous means. Property is contiguous to the residence if it is touching the residential property, even corner to corner, and is not separated by property owned by others. Property separated by a public right-of-way, such as a road, is considered contiguous. So corners touch, good enough to be contiguous. Across the street, because it says property separated by a public right-of-way, such as a road. So they even mentioned road is considered contiguous. So pretty broad there. And then it has note, do not rely on homestead exemption status for determining home property. Okay, so Louisiana has a property tax and it says don't rely on what the property tax assessor is your home for purposes of Medicaid's definition of home. All right. And then it says do not count home property or the value if the applicant is living in the home or if away from the home temporarily because of natural disaster such as a flood, away from home because of his medical condition and is keeping his home available and intends to use it at his home when his condition permits, or away from home and the spouse or dependent relative lives there. So if the spouse lives there or if the Medicaid applicant is away from the home, but they intend to use it as their home when their condition permits. So fairly broad definition of home there. So, and now there is another place in our definitions section of the Medicaid manual that talks about how it specifically mentions how many acres a home could be. So we have a definition of what's called homestead in the definition section, which says the homestead is one or more tracts of land with a residence on one tract and a field, pasture, or garden on the others, not exceeding 160 acres. That's a big piece of property. I don't think I've ever lived on more than a couple of acres. Includes rural or urban buildings and improvements. So anyway, just wanted to mention there was that 160 acre item in there in the definitions. All right. Yep, there you go. So good point there on the live chat. Johnny, so instead of spin down, if you transfer funds into the irrevocable trust before the clock starts, the recurring income minus allowances. Yes, that's a mouthful there. I'm because my brain's going so fast, I'm not able to slow down enough to really analyze that one. Let me get to the next one. I'm gonna come back to that one, Johnny. Giving the kids the house makes them use the original cost basis, I believe, a consideration. Yes, that is a consideration. So especially if there's been significant appreciation in value since the parents typically acquired the home. Parents acquired a home for $150,000. Now it's worth $400,000. If the parents donate the home to the kids acquire the carryover basis of $150,000, whatever the parents' basis was. But if the kids inherit the home, they'll get a stepped up basis, which will be whatever the value is on the date that the parents pass away. Let's say it's $400,000. And so that step up in basis will save the capital gains tax on $250,000 of capital gains. So good point there, DKS. Okay, so we've defined home property. Let's see what we got going on next here. All right, next thing I want to go over is there are some provisions. I know it's in our federal law, so it works in most, if not all states. Before I get into that, wanted to mention there is a limit on the value that a home can be. So someone can't say, well, I've got a $4 million home. It's exempt. I have $1,500 in my bank account. I qualify for Medicaid. Medicaid pony up all of my long-term care expense. Well, can't do it with a $4 million home. We have a home equity limit. And so it gets adjusted every year, goes up a little bit. So the home equity limit for Louisiana Medicaid applicants in the year 2020 is $595,000. So if you have a house worth $550,000, you'll be eligible for Medicaid. If you have a house that's worth $650,000, we got a problem because the home equity limit is $595,000. Boy, I don't even know what you'd do. I guess you'd sell that house, maybe buy another house, and then have to spend the excess. I don't know. Most people who have a house that is valued in excess of $595,000, at least in my area, they probably have enough other resources where Medicaid is not a concern. So that's not the case in every case, but now you know the rule. There's a home equity limit. Okay, next what I want to get into is there are certain areas where people can transfer their house and there's no penalty. So that avoids the Medicaid estate recovery. There's no 5-year penalty period for transferring the home. Let's look at some of those exceptions to the application of the transfer of asset penalties. All right, so we got a couple of them here. So this is Medicaid says, well, your circumstances are so unique that, we'll let you protect the home. We'll let your family save that value. So there's a couple of them, and here they are. So this is an exception to being penalized for transferring the home if, and the grammar here is bad, it says the transferred is the individual's home and title of the home is transferred to the individual's spouse. Medicaid lets you transfer assets among spouses, no problem there. But there's other problems with spouses owning assets. But they also say it's okay to transfer your home to a child who is either under the age of 21. Okay, so if you got a child who's 20 years old, you can transfer your home to your child, no penalty period. Or a child who is blind or permanently and totally disabled as defined by SSI at the time of the transfer. The age at onset of disability is not a factor. So there's a number of children of parents out there who are deemed blind or permanently and totally disabled as defined by SSI. So if that's the case, you can transfer your home. The rationale, that child's probably going to need a home to live. Government says, let that home, stay in the family so that child has a place to live. Medicaid's not going to pursue it or penalize you for it. And then there's more. I guess there's two more. You can transfer your home to a sibling who has an equity interest in the home and who was residing in the home for a period of at least 1 year immediately before the date the individual became institutionalized. All right, not uncommon for 4 children to co-own a home because they inherited the family home place from their parents. And let's say, child number 1 is about to go to the nursing home, but they own a 25% interest in a $300,000 home. If you just did some math, that 25% interest would be worth somewhere around $75,000. That's a problem because that's a countable resource. So Medicaid says you can transfer that ownership interest in the home to the sibling who also has an equity interest and who was residing in the home for a period of at least 1 year immediately before the date the individual became institutionalized. So there you have it. And then the last one, this is used quite a bit when a child, moves in with the parents to take care of the parents. You got to admire children who do that. So it's a tough job, but it's a very probably rewarding job. And sure enough, the parents, raise the child. So maybe that's the least the child could do. But a parent can, without penalty, transfer their home to a child who is age 21 or over, not blind or permanently and totally disabled. And here's the kicker: was residing in the home for at least 2 years immediately before the date the individual became institutionalized, and provided care to the individual, allowing the individual to reside at home rather than an institution. What does that mean? All right, so daughter moves in with parent to take care of parent, and daughter lives in the home with the parent for at least 2 years. And the fact that the daughter moved in with the parent kept the parent from having to move into an institution. And then there's one final note to that exception. It says the exception must be documented by written statement from physician indicating his or her knowledge that during the preceding 2 years, the individual's child was present in the home as the primary caregiver. And if not for the care provided by the child, the individual would have required care in an institution or through a CBS. So you have to get a doctor to sign an affidavit that says, look, the daughter moved into the home. She's been living with the parent for at least 2 years. Had the daughter, not moved in and started taking care of the parent, then the parent would have had to go into a nursing home. So that's sufficient to allow the parent to transfer that home to the child without penalty. All right, so there you have it. There's some exceptions, and then the other. So those are great. If you not every family meets one of those requirements, but if you do, home protected. Now we need to look at, if you don't follow one of those exceptions, what do you do? The concept is again, like anything else, plan ahead for Medicaid 5 years in advance. In fact, I just noticed a question from Bob. I'm 60 and disabled. What's the amount to be considered in payout status to make the 401k exempt from Medicaid recovery? That one's a little beyond me. And here in Louisiana, the 401k, the IRA, the retirement account is a countable resource, regardless of whether it's in this payouts or in pay status. Other states, if your IRA is in pay status, and it's been told to me by a colleague where, if you're taking required minimum distributions, that's in pay status, but that doesn't happen starting this year and until people are 72 years old. You're 60 and disabled. I would say check with someone in your specific state about that. That's one area I can't help you, but it's a great question, Bob. Keep them coming. I make every effort, and over 10 consecutive days, there hasn't been a question that I haven't at least attempted to answer. So I really love the live chat. Also, any experiences, or some of you watching may know some answers to some of these questions. So you can put it in the live chat or in the comments below. So what do? You have a house. You don't meet any of those exemption deals. So in order to avoid Medicaid's estate recovery, you got to get it out of your name. And so what are your options there? You can transfer. What some people do is they just transfer their home to their kids. And we see where, DKS pointed out that there's a carryover basis issue there. Sometimes that affects some people, sometimes it doesn't. Another concern about just putting the home in the children's names is the parents no longer control the home. And so if a child dies, if a child has a creditor problem, child has debts, child racks up a bunch of credit card debt, potentially a problem if a child gets divorced, if a child dies, and then that child's interest in the home goes to the grandchildren. Some serious lack of control issues involved when you just transfer ownership of your home to your children and they co-own it. But it gets the job done for the Medicaid eligibility purposes, as long as there's not a Medicaid application submitted when you're in a nursing home within 5 years after the date that transfer is made. Because when someone goes into a nursing home, part of the Medicaid application process, have you transferred any resource out of your name in the previous 5 years? And if the answer is yes to that, you've got an eligibility problem. All right. In another video, you mentioned I think grantor is what you're getting at, grantor trust. What is it? Grantor trusts are trusts where you put assets into a trust, but you retain enough control over those assets that the income tax status of those assets doesn't change. The grantor, the person who set up the trust, the person who transferred assets to that trust, those assets are still, for income tax purposes, deemed to be owned by the grantor. So the trust doesn't have to file a tax return. The trust doesn't pay any income tax. All of the income that the trust assets, all of the income produced by the trust assets just get reported on the personal income tax return of the grantor. Probably the most common kind of grantor trust is the revocable living trust, but there are a number of other trusts that qualify as grantor trusts. And so you can check that out perhaps on another video. Good question there, Joseph. Okay, so the other option that a lot of people take advantage of is putting their house in a trust to try to get it out of their name. The idea there is you're getting it out of your name, you're making a transfer, starting the 5-year clock running, but in a trust, you're retaining more control over that asset after the transfer is made. So the children, they're beneficiaries of the trust, but they're not in control of the trust. So if they die, if they get divorced, if they get sued, if they have creditor problems, that home isn't going anywhere. It's going to stay in that trust until both the parent or both parents, whatever the case may be, pass away. And then the trust ends and assets are distributed out of the trust to the appropriate trust beneficiaries. So some people like the extra control that gives people when they transfer their home out of their name in an effort to avoid Medicaid's estate recovery rights, because at least in our state and in most states, Medicaid only has estate recovery rights over the home if the home is in your estate when you die. And Louisiana defines that as, if it's in your probate estate when you die, then Medicaid can exercise its Medicaid estate recovery rights. By taking that home out of your estate and putting it in a trust, then there's nothing in your estate for Medicaid to pursue under its estate recovery rights. Here in Louisiana, kind of a big deal to people in Louisiana is what's called the property tax homestead exemption. If you live in Louisiana, if you transfer your home to your children, if you transfer your home to a trust, you should probably strongly consider reserving this lifetime usufruct of the home, which enables you to keep your homestead exemption, and which probably is going to save you about $800 a year in property tax. Okay, so there you have it. We talked about the definition of the homestead, which is fairly broad. The home and lot where the home sits, plus contiguous property up to 160 acres, even if property is separated by a road, kind of a broad definition of home property. We talked about where you can transfer homes to certain people and not have any penalty period as a result of it. Transfers to people under 21, siblings in certain circumstances, and even children over 21 who, with a doctor's affidavit, can attest that the child lived with the parent for at least 2 years, and the child living with the parent kept the parent out of the nursing home for at least 2 years. The parent can then transfer the home to the child without penalty at any time. Okay, once those qualifications are met, then we talked about getting the home out of your name to avoid estate recovery. We talked about losing the step up in basis, perhaps if you transfer your home to children. Children get the carryover basis. That might be a big deal. So that's another consideration. And then we talked about putting things in a trust to have more post-transfer control to keep that home from going other places in the event something unexpected happens with children. And we talked about reserving the homestead exemption. So a lot there just on the home. And then what I want to do is make sure you do hit the like button, subscribe, all that stuff. Go to my website, click on my schedule, and call if you want to call. And then as of today, we'll be halfway done with our YouTube presentations. We've got 10 more to go. Tomorrow's a big one. Tomorrow, most people say, estate tax, not for me. I don't have to worry about it. But most people who are alive and watching these YouTube videos, they're likely to be alive in 2026 when our estate tax law is expected to sunset, make a lot more estates subject to the estate tax. So what you know now in 2020 may cause you to start taking some action to prepare for a death that might occur during or after the year 2026. So an important one tomorrow. So again, planning ahead on all this stuff is the key. All right, I hope that helped. If you got any last minute comments, put them in the live chat below. Last second questions, live chats. If not, if you're watching this on a pre-recording, put them in the comments below. What I like about doing the YouTube live presentation, YouTube makes a recording of it and they put it on their website, on my channel. That way, while maybe a few dozen watch live, hundreds more will watch the recording. And we got some more questions. Let's see. If the home is in a trust and one spouse dies, can the home be sold to downsize for the remaining spouse? Good question. In most circumstances, yes. One spouse dies, the trustee of that trust, which might be the surviving spouse, might be one of the children, can sell that home. And then the proceeds of the sale of that home, let's say they sell it for $350,000. At the closing, the check is payable to the trust for $350,000. That check gets deposited in a trust account. All of that's still protected. And then perhaps the trust goes out and downsizes, as Joseph says, and buys a $275,000 trust using the trust money to buy that house in the name of the trust. No new 5-year waiting period, none of that. So yeah, certainly is permissible for homes that are in trusts to be sold, and then even permissible for the proceeds of that sale to be used to purchase a new home. Are nursing homes required to accept Medicaid patients? Good question, Ron. My short answer is no. I just really telling you from practical experience, there are, at least in my town of Baton Rouge, Louisiana, I know of 2 facilities that provide, skilled nursing care, and those 2 facilities do not allow Medicaid patients. It's all 100% private pay. And then in my community, there's probably a dozen, skilled care nursing home facilities that accept both Medicaid and non-Medicaid patients. So nursing homes are not required to accept Medicaid patients. I don't know if that's what you're getting at, but I know, in fact, in other cities, I'm very aware of skilled care facilities that are exclusively private pay, and typically they're a little more expensive and kind of higher end, but you're paying for it. Okay, so great job with the likes. I see right now we got 14 people on the call. Now 15 and 17 likes. I like to see those numbers. That means we've had some more people on. What is the cost of a trust? Tough question. Just kind of like, you're kind of asking me like, what is the cost of a home? At least in our office, everything we do, we like to talk to you, find out your circumstances, figure out the easiest way to accomplish what you're trying to accomplish, and then let you know a fixed reasonable amount to get you from where you are now to having everything, it set up the way it needs to be. And everybody's circumstances are different. Some are simple, some are complicated, some have more assets than others, some require more customization than others, but at least we give people an opportunity to explore without any financial commitment to get informed so they can make an informed decision. And quite frankly, I'm not sure, Joseph, whether you're asking me or whether you're asking just in general, because if you're asking in general, you could talk to 5 different lawyers with the same set of circumstances and get 5 completely different answers as to what any financial amount would be to put things in place. Good question there, Joseph, though. You're welcome, Ron. Thank you, Ron, for the fantastic joke that you provided at the beginning of the live chat. We'll see you tomorrow. I got to go take care of some client matters, and y'all stay safe, be good, and see you tomorrow. Bye now.